Hello guys, welcome back to Legal Banter. Today's video is dedicated to understanding what is privacy and its various forms. Now privacy has been adjudged as a fundamental right in the notable case of Puthuswamy. But it wasn't that first case that marked the acceptance of privacy and its various forms. Even prior to Puthuswamy and even after, there have been cases of the Supreme Court as well as various high courts which have recognized various forms of privacy. Now, understandably, privacy is not a static concept. In different contexts, it takes a different shape. For example, in certain cases, right to privacy becomes synonymous to right to autonomy. For example, what I do with my body, whether I have a right to abort if I want to, what are my reproductive rights, becomes a part of my autonomy over my body. Similarly, it can also transform into right to choice. For example, who I want to marry, who I want to be with is an aspect of my choice that I want to exercise, and the same is protected under my privacy. Third is the right to be let alone. In various cases, the courts have held that privacy also means that you shall not be disturbed, any aspect in which the state should not interfere. For example, in the Navtej Singh Johar case, the court held that a person's sexual life and his choice with respect to who he wants to be with, who he or she wants to be with, is a part of his rights to privacy. Now, today's video, we will look at all the extensions of this privacy that the courts have recognized over a period of time. The same way, life in Article 21 has been given various connotations and has continuously been expanded to include more and more aspects of life and personal liberty. Similarly, privacy has also been such an expanding term. In today's video, we will look at all those various extensions and the cases where those extensions were recognized. While discussing the layout, I have not necessarily followed a chronological order. However, if you will check the description box, you will find the list of cases in the chronological order. So be sure to check that out. The first aspect of right to privacy has been right to marry or right to choose who you want to marry. This has been accepted by the Supreme Court in the case of Shafin Jehan versus KM Ashokan. Another aspect of privacy has been privacy over your documents. Now, documents are further of two kinds. We have financial documents and we have medical documents. With respect to medical documents, the court in the case of Mr. X versus Hospital Z accepted and recognized that a person does have right to privacy over their medical information and records. So far as financial records are concerned, the court in the case of District Collector Hyderabad versus Canara Bank has held that financial privacy or documents of financial nature are also covered within the scope of Article 21. The court extended the scope of privacy next with respect to sexual privacy or sexual relations. Now, the court has seemed to interpret this in three possible directions. First of all, in the case of Krishnappa, the court has held that when an act or an offence of rape is committed, apart from it being punishable under 375, it is also an invasion of a person's privacy. Another aspect of the same sexual privacy is what the court held for the first time in the Nas Foundation case and followed by the Navtej Singh Johar case in 2018. Both these cases collectively hold that a person's right to choose their sexual partners is something that the state cannot interfere with, and consequently, Section 377 of the Indian Penal Code becomes redundant. The third aspect of sexual privacy is with respect to the virginity test. Now, in law, there is a very unfortunate test which is called as the two-finger test that is usually carried out to determine whether the woman or the female is a virgin or not. Thankfully, this test has long been held to be unconstitutional and is no more followed. With respect to that, there is a very notable case of Surjit Singh versus Kamal Kaur, where the husband wanted the wife to undergo a virginity test because the wife had sought divorce on the ground of impotency of the husband. So the husband, in order to counter the argument of impotency, argued back, stating that the wife had to be tested whether she was a virgin or not, because if she was found to be a virgin, then only the fact of impotency could be proved. So this is collectively what the court in different cases has accepted with respect to privacy. Another aspect of privacy is when you are asked to cooperate in court or quasi-judicial proceedings. For example, in the case of Sharda versus Dharampal, there was an issue between a couple, and for that the DNA test had to be carried out. When the party refused to undergo the test, the court held that they had every right to refuse to the test, but if they did so, the court was free to notice an adverse inference and consider that in the case. The court rejected that this will amount to an invasion of privacy. However, the court in ordinary scenarios does accept that a person's right to privacy extends even when he does not wish to cooperate in any court proceedings. This also happened in the case of Narayan Dutt Tiwari, a very senior member of the Congress political party, when a person came into public light stating that he was the biological son of the politician. On the instruction of the court, the politician refused to undergo the test. However, the court accepted but stated the same thing with caution, that if you were not to cooperate in the test, an inference adverse to your stand will be taken. The next aspect of privacy has been considered in respect of taping a person's telephonic conversation. This issue before the court arose first in the case of R.M. Malkhani versus State of Maharashtra, where the issue was that when a person was trying to extort money from another person, that telephonic conversation was recorded and was used to be as an evidence against him in a court of law. To this, he had stated that this was a violation of his privacy under Article 21. Even though the court recognized such a right, the court did not accept the right was available to the said petitioner in this case. The court based its decision on the famous idiom that one should always approach the court with clean hands. Another aspect of privacy over telephonic conversations was in the case of PUCL versus Union of India. This case marked a huge departure from the R.M. Malkhani case, where the court accepted right to privacy as a tangible form. The court, however, did lay out a caution that in case of any telephonic conversations that had to be tapped, a proper procedure that the court laid down and the guidelines that it laid down had to be followed. The next aspect of privacy is with respect to police surveillance or surveillance in general. Now, the court was confronted with this issue in two notable cases. For the first time in the case of Khadak Singh and for the second time in the case of Gobind. Both cases had a similarity in the sense that they were pertaining to the constitutional validity of certain police regulations, whereby domiciliary visits, unannounced police visits, your reporting to the police station was required. The court in the case of Khadak Singh, whereas did not accept the enforcement of a fundamental right as a right of privacy, but in Gobind, the court went a step ahead. Even though it did not allow the defense of privacy to apply in the case of Gobind, Justice Subba Rao in his dissent did pave way for privacy to be recognized as a fundamental right later. Another important aspect when privacy seems to be challenged is when, as a part of judicial procedure or police investigation, a person is forced to undergo invasive tests like narcoanalysis, beep, or the polygraph test. The court, popularly in the case of Selvi versus State of Karnataka, has already declared all such tests as unconstitutional and has laid down a proper specific procedure in the event where such tests have to be carried out. One also has to bear in mind that even when these tests are carried out and findings adversarial to the deponent are found, such evidence is not admissible in a court of law because it directly contravenes Article 20 Clause 3 of the Indian Constitution, which provides the fundamental right against self-incrimination. A landmark decision which extended privacy to yet another level was the case of Puthuswamy versus Union of India. In this case, the constitutional validity of the Aadhaar Card Act and its mandatory linkage to the PAN card of a person was challenged. The court, amongst other things, held that right to privacy was a fundamental right. Even though on various other sub-issues, the bench of 9 stood divided, Yet, when it pertained to right to privacy and whether it should be accepted as an extension of Article 21, the bench unanimously held it in the affirmative. The last aspect of extension to privacy has been done recently by the Allahabad High Court. In this case, the court had stated that the mandatory requirement of sending out a notice, a public notice rather, under the provisions of the Special Marriage Act when a couple belonging to different faiths or religion are planning to get married had been struck down by the court as unconstitutional. The court has further held that this invalidates and violates a petitioner's fundamental right of privacy. The court obviously has based this on the decision given by the court in Puthuswamy, followed by the case of Shafin Jehan. Both of them put together, the court was able to rule, even though it was a high court, it has been able to rule that yes, privacy over matters which are mandated under statutory laws like the Special Marriage Act can also be held to be unconstitutional because they violate a person's right to privacy. I hope through this video you were able to understand the various forms of privacy and how through various decisions those have been recognized by the courts. But if you want to know how this right to privacy in the first place developed as a fundamental right, how in chronological order did courts accept it as a fundamental right, you can check out another video that I have made on the same issue. I will provide the link in the description box and the link will also be there on the screen. I hope you like this video and learned something new. If you like the content, please hit the like button, share this video with others who might be interested and subscribe to my channel Legal Banter. Thank you so much for watching.